Hey everyone, welcome back to the REI Marketing Secrets podcast. Today on the show, we have Tilden Moschetti. And Tilden, for our audience out there who's just learning about yourself for the very first time, do you mind just going over your background a little bit and how you got started within the real estate space?
Sure. Yeah, absolutely. I started in real estate really just because I knew I wanted to be in it. My even as a little kid, I would draw like floor plans of our house over and over. That was like my hobby. So I always knew I wanted to do it. I went to college, ended up getting an MBA, and then out of my MBA, I decided, what I'd really like to do is develop properties. So uh, as I looked around and trying to figure out how I was going to do this with no money, I found a lot of people were also attorneys, and I thought, oh, that seems to make sense. If I understand the law, that must be, have a lot to do with what underlies everything. So why don't I go do that? Because I was never going to be the guy doing the actual construction. I'm my wife makes fun of me all the time at how unhandy I am at those sort of things. So uh, it seemed the best way for me to go was the business side and the legal side. So I went to law school. Did all my studies were really focused on that. Took a slight detour though towards the end of my law school, as I was doing a trial advocacy program, and I really enjoyed trial at that point. Um, so I got out of I graduated from law school and decided to hang up my shingle. I worked first for a very short time at the district attorney's office, and decided to be a litigator. After the district attorney's office, I with my shingle hung out. I really kind of focused in right immediately on real estate, but not like landlord tenant because that didn't really interest me very much. More like, if there's a property dispute, how do we resolve it? So that means a lot of family law, bankruptcy, partnership disputes, sort of what underlies value and ownership of the property. I did that for 10 long years. And I say 10 long years because being a litigator is a very unhappy world, with a lot of people, and emotions high. So I was getting really burnt out. And then I started doing some brokerage because I saw a lot of brokers making a lot of money. And so I thought, okay, that seems like a good idea. And then one of my broker peers came to me and said, look at this deal. It's really great. And I looked at it and said, yeah, it really is a great deal. And he said, we should syndicate this. And I said, okay. I didn't quite know what that meant. I mean, I had known the name, but I figured, hey, I'm an attorney. I got to figure it out. And so that started. We decided to syndicate it, and it was pretty successful. We got investors, had about 20 in that first deal, and it was a great process. I learned a ton on the way. Did another deal after that, and then by that point, I had a lot of momentum. I was really good at the legal side and putting everything together. So I transitioned my practice away from litigating. I don't litigate anymore at all, and focused really in on syndication. And primarily, most of my clients are real estate syndicators.
Yeah, I think it's a pretty interesting story because anytime I come across someone similar to yourself, or as a syndication attorney, not many of them have ever done a syndication themselves, have gone out there and had
Yeah.
investors. And I find that's very fascinating on your end because you have that experience. You've gone through, you've syndicated a deal, you know what that whole process is like, especially for us out there that are passively investing, like one of your 20 investors. But just out of curiosity, what type of asset classes were you syndicating for? Was it more multifamily, or was there other types of investments that you were raising that capital for?
No, I rarely do multifamily. Actually,
Oh, wow.
I mostly do. My first deal was a single tenant medical office with a credit tenant, and then moved from there. Did a lot of. I really liked the retail space because I like the complexity of it. So I've done retail. I've done multifamily. Just like one or two multifamily buildings. I've done ground up development primarily in the retail space. office, value add office, um, and certainly value add retail as well. I haven't done a hotel yet. I also really like flex and industrial.
Yeah, and I agree with you. I like flex and industrial. I like where it's just nice and simple. I like the tenants that
Yeah.
come in, but with that
Yeah.
said, let's say there's someone in yourself and they've done a couple of real estate deals and they're like, okay, I want to scale. How can they start? How can they start their syndication business? What does that look like? Is it really working through someone like yourself first, getting through all those documents, getting all their ducks in a row? How does that sort of look like when someone's wanting to start their syndication business?
Yeah, I mean that's the way it normally happens. Is they do a couple deals and they want to grow, either grow or they want to do more deals, or they want friends and family have been watching them and want to invest with them. That tends to be the start of it all. I get brought in at all sorts of different points as an attorney. I mean, I've because I have a background in doing the deals myself. I've been where they are. I kind of know what they're going to hit ahead of time. So when I get brought in early, it's normally let's work on the business plan. Let's figure out what that is. Let's figure out what I call founder investment theory is. What makes you special, or what makes what your all your offerings going to be that makes them unique, and kind of explore that, and then start working on documents and putting them in place. We normally do documents at this point in the market. We're doing documents first most of the time because we still have short times to close, and it takes a little bit longer to raise the money than it does to close, and so it's really challenging if you don't have the money ready at hand. We also need the documents in order to accept client money. And so they kind of have to get done anyway. And they can be flexible until we start getting that money in. And so normally I look at like a PPM as kind of evolving. It changes a lot at the very beginning, and then it gets kind of set and nice and stable.
Yeah, I think that's super helpful for our audience. And let's say someone out there, someone like myself, where maybe I don't want to raise money from a ton of investors, but I want to raise it from, let's say, my family, my immediate family. Is it necessary for me to have a PPM, or do I even need one, or how does that sort of structure look like?
Almost always. So it's almost always required, and it's always important. All right. It's so the what you'd really go by is, if you're filing under what we call Rule 506C, which is we can raise money from accredited investors only and we can advertise. Technically, you don't need a PPM. It's not a required document. There's still information that it needs to be conveyed, but it doesn't need to be as formal as a PPM if it's a 506C. Now, if you have any non-accredited investors, or you're not verifying they're non-accredited, that they are accredited investors, at that point the SEC is very clear. You got to have a PPM. That said, even people doing a 506C, it's almost always you're going to do it, because why wouldn't you? I
Mhm.
mean, almost always your investors are paying the legal fees. They're reimbursing the person who putting the fund together anyway. And so there's just this high level of protection when you've got a document. At the end of the day, you can hold up and say, see, I told you this is what was going to happen, or that this was a risk, or that this was the terms. Remember, we talked about the preferred return was going to be 8%, but it wasn't starting until we deployed it, or whatever those things are.
Yeah, I think that's very good to know. And just out of curiosity, just for someone like myself, so whenever I'm investing in the deal, I go through the PPM, and I've heard of other investors. They're just like it's too long. Sometimes it's 50 or 60 pages at a time. I'm curious if there's like a certain. Obviously, you want to go through it all, but is there certain sections that you would recommend for a passive investor to go through? Like I always look at like what happens in the event of a capital call. What happens in the event that the operator passes away? Like who's going to be the next? Who can make those decisions if there's I don't know what you'd say like hostile takeover, but if they're not doing a good job managing the property, can we vote to kick them off as the managing operator? Just curious if there's like certain areas you'd recommend for a passive investor to really read through
Yeah.
just to make sure they're going to be safe investing in a deal.
Yeah, I mean, there are certain things that are more boilerplate, for lack of a better term. I mean, they're important, and they need to be there, and they need to at least be skimmed so you understand what the things are. I mean, I'm talking mostly about the risk sections, right? Under risks, you need to know that all those risks are there, and so it's important to at least know what they are. So the big headlines are the most important, and if there's something like that seems unclear, then it's worth reading the whole section. But certainly, like, all of the terms are the most important. I mean, I don't know an investor whose primary concern is probably how distributions happen,
Hmm.
right? So everybody's going to go to the terms section and read how distributions happen and make sure they understand it. I think some of the things that are a little bit less clear, that maybe people don't read as much but should, is how the manager is structured and how they tend to operate. What discretion do they have? Do they have a voting section where everybody needs to vote, or how are those decisions in the middle of the process going to be taken care of? I so Looking at the management, and likewise, if there's a conflicts of intersection, probably at least skimming it to see, are there any conflicts that you haven't thought of? Because in syndications there is always conflicts. It's guaranteed, because you have somebody making fees off of this product, and either they're getting a better benefit by having it prolonged, or they're getting a better benefit by having it shortened, or there's various like levers that can move. So it's important to at least understand that they're there and be able to read those.
Do you ever come across a time where maybe a particular individual investor is looking to get the PPM change? And I'm just thinking about this because I was actually listening to a podcast, and the guy runs an investment group, and he can bring a lot of capital to the table. You could think of maybe it's a family office, and they're bringing, let's say if their raise is 10 million bucks, they're dropping in $5 million, so they're going to want better terms. Honestly, they're going to go through the PPM and want to make adjustments. Have you ever come across scenarios like that where, for me as an individual investor, if I'm putting 50K into the deal, it's going to be a little harder for me to have them redo the PPM. But for a bigger investor where they're bringing a large chunk of capital, maybe they want a little bit better preferred return, or maybe if a capital call happens, they want to lessen their risk. Just curious if you come across any scenarios like that where, on a one-off basis, where you, in a particular deal, like one set of investors have one PPM and then another investors have a different PPM, just based on how much capital they're bringing to the deal.
Yeah, it won't necessarily be another PPM, but there's something you should look for in every PPM called, there should be something talking about what we call side letters. So
Mm.
side letters are agreements on the side that are made between a sponsor and an investor. Most of the time, those will be for people like your family office, or a bigger size investor, or maybe it's just an early investor that you want to help out, or somebody who's helped you out a lot, and so you want to change those terms. So there will be like a side letter that says, well, instead of the profit split being 70-30, it's going to be 80-20, or whatever it's going to be. Most of the time we're dealing with terms that are non-dilutionary, so they're not going to dilute other investors, because that's a big problem that we
Hmm.
don't want to have happen, is have somebody, not be told that they're going to be diluted out, which can happen if we change like a preferred return, right? For somebody, it can automatically dilute them out, because the pool of money that's being split is changing for them. um, so those tend to take place in a side letter. Normally, if it's something in an operating agreement, something like that, something that's a little bit bigger, that's not a specific term, it'll be really only from like a family office or from an institution, and there it's about control. So it's okay. We trust you, sponsor, in order to get this project done, but if things start going wrong, we need to be able to pull this thing back and take over. And so things might shift in an operating agreement like that. It's not super common, but it certainly does happen.
Yeah, no, it's definitely interesting to hear. And now you have the people that are going out there. You're raising the capital, or let's just say you want to put together a syndication deal, and then now obviously you have to go out there and raise that capital, how can someone ensure that they're going out there and raising that capital legally so that the way they're not getting themselves into any hot water?
Well, fortunately, the rules are really spelled out. Regulation D is a super set of rules. It's really, really clear. And although we have gray areas, it's the gray areas are where people don't get into too much trouble. It's those bright line, clear things. Is you're either compliant or you're not. So you're either verifying that people's an accredited investor when you're putting together a 506c, or you're not. I mean, it's one or the other. And so the best way to make sure that people are in compliance really is to understand the whole role of what that compliance is there for. The SEC and the state regulators are there to protect the public. That's their job, that's their mission, and the people who do it are very smart, and they feel good about what they do every day. They're not bad people out to hurt syndicators trying to do their job. They're trying to protect the public. So the best way to stay on the good side is give the public what they need,
Mhm.
right? So that's certainly disclose, disclose, disclose. Always disclose. That's the super easy answer to protect like 99% of anything that could go wrong. Is if you told them, you've told them. It can't get much worse. It can't get better than having told them whatever it is. The other things are really just working and just having a commitment to doing the right thing by your investors. I would be surprised if a regulator, when they were looking and deciding whether to pursue a matter, if it looked like the sponsor was really doing everything they could to help them out, I would be help the investor out. I would be surprised if there would be a bad action against them. I mean, they certainly could, but if the intent is out there to always do right by your investors, you're almost certainly going to be much closer to the right side of compliance than not.
Yeah, and I think that's spot on. Even if the deal goes sideways or something doesn't work out, as long as you're doing everything in your power to make sure everything's, like you mentioned, disclosed and you're in compliance. Again, even the best syndicators out there, maybe a deal or two doesn't go right for them, but as long as they have that in place, it's not going to look as bad for them. But I want to talk about some of the common mistakes you might see syndicators going out there when they're raising capital, and one that comes to mind. I know we were talking about it a little bit before the show. Is I not always, but I'll go on LinkedIn and I'll see these 506B deals, which that's the problem right there, is seeing these 506B deals on LinkedIn, and they're being talked about and advertised. And I know for me as a non-accredited investor, my common knowledge is that I can't be advertised to. I have to have a pre-existing relationship, and for me that means I have to reach out to the sponsor and start that relationship with them. But curious if there's any other mistakes you see, whether it's a 506c deal or any of the other type of deals offering or 506b. Just curious some of the mistakes you see these syndicators going out there on doing, whether it's advertising it when they shouldn't be advertising it, or whether it's bringing in too many non-accredited investors. Just curious what you've seen on your end, if more so for just so people don't make these
Yeah.
mistakes going forward.
Yeah, I don't see. I mean, certainly there are people that bring in too many non-accredited, but I mean, the rule is 35 non-accredited investors in any 90-day period, which means we've got some wiggle room. So if there is a way to stretch out that period of raising from if everybody came in day one, we got 35, and then in day 91, we can bring in 35 more. So that gives us a lot of latitude in order to bring in quite a lot of people. So normally I don't see it like going over the top. I think what sponsors struggle most with is really the sale part of the security.
Mm.
And so how do they do it? How do they find investors? How do they make this all work? And so it gets overly tempting to use finders and to pay finders, and to pay people who are not licensed in order to uh, to bring you people. So I've seen deals where we've have, okay, well, instead of paying you a finder fee, we're just going to bring you in on the GP. And some of these people bring in like 10 co GPs. And
Mhm.
I think if I was a regulator, I'd kind of be like, "Come on, really? This is kind of ridiculous." It's kind of obvious what's actually going on there. So I think the temptation is out there to go much more to the gray side of it when we're trying to find as many investors. uh, and I get it because I've been there and I know, I've waived contingencies on a deal and not had even half the money yet, and know that, I'm about to lose all the deposit I put in if I don't get it. So I've been there, but that's a big one. Is finders you'll get in trouble for. Non-finders, people bringing you clients, it certainly works, but you just can't pay them.
Yeah, it's funny that you mentioned like the 10 code GPs. It's sometimes when I'm going through an investment deck, you'll see it and there'll be like 15, 20 team members, where usually it's like maybe 5 on the GP team, or or maybe give a couple. I'm like, okay, I'm like, I got to split all my money with all those people. Like, I don't know if I
Yeah,
want to be
they're
investing.
always in different places around the country, and
Hmm.
you know that there's no way they met each other. So it's like, come on, I don't see this.
Yeah, exactly. And I want to get to another point I know we were talking about a little bit before we hopped on the show today. And it's something I've come across with different sponsors and investing with them, where I'm a part of a deal where it's me and 10 other guys. We're all non-accredited and we have one LLC, and we invested in a deal. And I found when talking to some different sponsors, some would count that as 10 non-accredited investors and some would count it as one just because the LLC. And it's been interesting to me because on mine, I think that I would want to count it as 10 just to stay in compliance, make sure I'm not, you know, just want to make sure that it's still good in that sense. And then I'm not like taking on, let's say you take on 35 LLCs that each have 10 members, you have 350 non-accredited. I mean, that seems to be a bit inflated, but curious what your thoughts
Yeah.
are, or what the actual like law is when it comes to that, whether it's counting as one LLC or whether it's counting as the 10 non-accredited investors.
Yeah, I mean the law is actually really clear. It is you count every investor unless that the LLC itself has over $5 million of investable capital and was not put together just for the purpose of investing in this one thing. So that would be one reason that we could count it as one if it fit that criteria. Rarely does that happen. So normally people are coming together into LLCs to meet that minimum investment threshold, or because there's different tiers of payout at different amounts that are being put in. So you have to count every single investor, and it's pretty darn clear that yeah, that's what you have to do.
Yeah, yeah, it's kind of sketchy to me, to be honest. When I see them, the only one to count it says one, because I'm like, if they're trying to bend the rules a little bit here, it's like, what else? What are
Well,
they going to do?
that's
Yeah,
That's exactly the thing, and the SEC is not blind to this. I mean, they in their last report on accredited investors, there was a lot of concern about the level of accredited investor, and they really, I think, want to raise the bar. They want to make it more challenging to be an accredited investor. So 506B lets us have these 35 non-accredited investors, but trying to push things out, I mean, I could theoretically have, almost an infinite number of non-accredited investors as long as I keep scaling it with, LLCs. And SEC knows this. These are very smart people. They know what's going on. Just they don't investigate every deal that gets put in, right? They investigate once there's a lawsuit. Then that's when there's at least an inquiry into what happened. Um, and so most of the time it doesn't raise to the level that it's something that they would even see.
yeah, and yeah, that's a good point. I mean, and how many deals are going out there every single day? I don't know if
Yeah,
they have enough staff to comb through all of those. But something I've come across, and it's been an interesting strategy. I was talking to an investor the other day where he sets it up as a 506B deal where they get friends and family in. And then I don't know the timeline, but let's say a couple months goes by, and then he moves it over to a 506C deal where he can now advertise it. Curious if you've seen that strategy used before, or
Yeah,
what that
we do
looks
it
like
all.
on your side.
Yeah, we do it all the time. So extremely normal. So it's kind of one of my favorite, and so
Mm,
it's when I have a sponsor and they said, "Yeah, but I got all these people in my network that I want to be able to do it, but none of them are credited." I mean, this is the solution. So the solution is you form it under a 506B. You put the offering out there. You get all the investors that you can that are non-accredited. You tap out your network, so you've brought in everybody that you can. So that way, then it's as full as that's going to be. Now, the policy is that after 30 days, we don't consider it the same offer anymore. So the offer that was made under 506B, as long as 30 days goes by between when we mark that closed and then we open up a new one, a new offer under 506C, it's not the same offer. It's totally separate. And it's okay too, because the SEC shouldn't be concerned because none of those non-accredited investors saw the advertising, right? Because the
mhm.
advertising comes now 30 days later. So that concern over non-accredited investors getting in isn't there anymore. So what I do is I formally close off at least I mark it in the Edgar database. So where we file our Form Ds, I mark it as, we were trying to raise 1.5 million, even though we were really trying to raise seven. We were trying to raise 1.5. We raised 1.5. We have nothing more to raise. 506B is closed as far as that is. Now I file it as a new offer under 506C. 30 days later, it's a brand new offer. The terms may be the same, but now if there's ever even a look, there's no overlap, there's no anything. And it was very formal, like this is the date that it was closed. 506B, no more new people at all at this point.
Yeah, I really like that strategy. It's just nice for me at being non-accredited to get into these deals where I see people that do that, and I think it is a very smart strategy to go out there and use. But let's say someone's going out there and they're looking to get started in syndication. What's the best piece of advice you'd give them when they're going out there and looking for a syndication attorney?
For a syndication attorney, I mean, for me, I would recommend looking for somebody with experience. I mean, I think it's kind of invaluable. My clients get to call me and say, you know, hey, I'm getting this from my investors. What do I do? And I've pitched so many times. I can give you the pitch on like anything, or whatever comes up along the way. I know what the investors are going to want to hear, just because I've had to do that myself. So I can give you what to say in that will also be a legal thing to do in order to respond. Um, and also just having somebody who's empathetic, who knows, okay, it's not simple to raise money. Well, I should say it's simple to raise money. It's just not easy, right? It takes work in order to raise funds. And so there's all sorts of strategies and tools that we can use to build that. And having an attorney with that kind of background just can kind of probably smooth that a little bit easier.
Yeah, I think that's spot on. And until then, I just want to say I really enjoyed our interview today. And if someone in our audience is looking to get started, their syndication, or maybe they just want a better lawyer, someone that knows what they're, someone a little more experienced knows what they're doing. What's the best way that they can get in contact with you or find more information about you?
Yeah, I mean our website's the best place. We also have tons of videos on YouTube, so that's also good. Our website's moschettilaw.com. I'm sure you'll link to it. And YouTube channel, just look up. It's YouTube / at syndicationattorneys.com, I think, or syndication attorneys. Or just look at my name and you'll find us.
Yeah, perfect. I'll make sure to include that in the show notes of today's episode. And thanks so much for coming on to the show today.
Absolutely. I really appreciate it. And thank you for having me on.